So we are live. This is Coffee with a Lawyer. We're streaming on Facebook, LinkedIn, YouTube, and Twitter. This is our opportunity to take your questions and give you the legal answers that you're looking for, with the caveat knowing that there is no attorney-client confidentiality or privilege during these calls. We are streaming. I do encourage you, if you have any specific questions, to schedule a confidential consultation. So with that being said, I do want to welcome some guests. Hello, Juan. How have you been?
We'll see. Great, Justin. How are you?
I'm doing good. Yeah, it's good to see you. Thank you for logging on. Every Monday, we're here 9 a.m. Pacific Standard Time. We can answer any of your questions. We have a regular guest, Anthony. So I'd like to just give him the opportunity to ask his question first and do an update, and then we can get into any legal questions you may have, Juan. And also, if you're viewing online, feel free to post some questions in the chat, and we'll do our best to get to it. We do like to have these meetings about like 20-25 minutes so we can get our week started. But I'll do my best to address everyone here. So, Anthony, do you have any questions?
Oh, yeah, I do. Is it possible to have two managers or two agents?
I would take a look at your contract. Okay. The contract controls. If it's exclusive, then they can prevent you from doing that. It should be non-exclusive. You want to look at the terminology in the manager contract, because it's probably quite broad, because they want their rights to be as broad as possible to cast the net on all your endeavors. You may want to look at it. Maybe it is limited to a certain area. I know you're doing entertainment. Maybe their manager agreement is limited to only your entertainment career. You want to look at it. I know you do writing. The language controls. It's the four corners of the document. That's the best evidence. Okay, so you really want to take a look at your contract and look at the language.
Okay.
And look for words such as exclusivity. Non-exclusive basis is what you would like. And then if it doesn't include that, maybe you want to renegotiate and have an addendum and asking for carve-outs. Okay, you want to carve out certain other rights that you can contract with another manager for. You want more specification. You could have a manager for your writing career. You can also have a manager for your business assets, your business dealings, other business dealings, your financial manager. You want to be specific in your contract language.
Okay.
So that would require to review the contract and read the full document. We have a policy called RTFD, read the full document. There's some provisions at the end that may impact the provisions at the start. So you have to read the full document.
All righty, thanks. I appreciate it.
One last thing too, especially with manager agreements. Yes, the four corners control, but you can also, there are certain situations where you can bring outside communications in to determine what the full extent of the agreement is. All right. Yes, the four corners is the best evidence, but so long as these extraneous communications, emails, text messages, do not go and conflict. They do not conflict with the four corners of the document. You can bring them in for clarification of what the agreement is. The whole principle of contract law is holding people to their promises, and the written contract is just evidence of that. So if there's outside communications that do not directly conflict with the terms, but add to the meaning of the contract, you can bring it in under what we call the parallel evidence rule. All right. But first things first is I would get some specification from your manager. Maybe have some written confirmation in an email, have them expressly consent to you obtaining another manager for this other area of your career, a specific carve out. You would want a modification to your manager agreement to specify that. Okay, so let's go to Juan, because I know he's a new guest and signed on first. And do you have any questions, Juan?
Thanks. Hey there, Justin. Yes, I do. So my question is about court appearances. If you don't live in the state that you have to show up at. So my situation is I live in Texas, but I have a court date in Las Vegas to show up. It's like a progress check to see how I'm doing on the courses I was required to do to dismiss my case, right? So it's on September 6th. And at that time, I was required to do 13 weeks of counseling. By the time of that court date, I will only have 3 weeks left to do. So I'm assuming, the judge will give me a 3-week extension, right? And then ask me to come back. My issue here is I don't live in Las Vegas, right? So would it be impossible to, do I have to book a plane ticket and actually go show up in person? Is my general question here. Just for this, just to tell them, hey, I've been doing my classes and that type of thing.
Absolutely. Most courts nowadays have gone remote. So the first thing I would do before, which, I would say the worst case scenario would be hiring an attorney to have a special appearance for you just for the purpose of this hearing, which I don't think you will need to do. I think what you can do is contact the clerk for the court. You'll have to go onto the website and find the page for the local courthouse and find the phone number for the clerk of that specific courtroom that your hearing is in. Call the clerk and ask if it's possible if you can make a virtual remote appearance. And what is the procedure for doing that? Nevada, I'm sure, allows you to do it. I know for sure in civil cases, we can do that. Now, if it's a criminal case, it might be different. They may want the body to present if it's a criminal matter. Okay, just different standards. The court has different reach, different jurisdiction. If it's a criminal matter, you may not even be allowed to leave the court's jurisdiction. That's what is posting bail. It doesn't sound like it is a criminal matter. It sounds like it's more of an infraction or maybe even a civil dispute. If it's a civil dispute, for sure you can have a remote appearance. I would say first thing would be to contact the clerk of that specific courtroom and ask her what is the process for that. Second point that you bring up, because you've completed a lot of requirements, and to show good faith, without getting into the specifics of the matter, if you want, we can do a private confidential consultation. We are streaming and I want to keep specifics out of it, and we could just speak in general terms. I would say, since you've made a lot of progress, and to show good faith in handling this matter, submit a declaration before. Again, I would contact the courtroom clerk and find out what the process is to make a civil filing in your case, and give them a declaration and let the judge know before this hearing all the good things you have done, the progress that you've made, appease the court. And any hearing, you want to step into it with clean hands. It's very, very important. You walk into that courtroom, clean hands. All right. So I would submit a declaration, giving the court some evidence of all the progress you've made. Look up the process for making a filing electronically. All right. All courts today have the electronic filing system. They encourage it. And they even encourage remote appearances. They really don't want people taking up the court's judicial resources. There's one overarching policy in all court matters, is judicial economy. All right. You want to be mindful of that. If you're handling your own case, be mindful of judicial economy. Don't unnecessarily take up the court's time, energy, or resources. If you can make it easier on the court, they will appreciate that. So a declaration before the hearing, with the proper captions saying this is in support of your position at the hearing of this date, so they know what it relates to. And just let them know this is an affidavit of good faith, all the progress I've been doing. All right.
Right. Awesome. Thanks, Justin.
And then worst scenario is if you cannot appear in person is to contact a lawyer to stand in your position.
Gotcha. Appreciate it.
But I think this is something that you can sort out with a phone call to the clerk and get the process for appearing remotely.
Yeah, hopefully, because I do appear remotely for my Las Vegas classes. The classes have to be in Las Vegas, but I appear remotely from Texas even for that. So
yeah,
hopefully.
absolutely. My general feeling is that the courts do appreciate remote appearances. Yeah, they just it just has made things easier on the courtroom and the process. You know, it really what's on the judge's mind is always processing the case. You know, they have a lot of cases. They want cases come to conclusion and off their docket. But yeah, keep signing on every Monday, 9 a.m. Pacific Standard Time. I want to give Jonathan an opportunity. How's it going, Jonathan? You're on mute.
Good. Okay, there.
Yeah.
Good. Thanks, Justin. How you doing?
I'm doing all right. It's good to see you.
Good. Yeah, good to see you too.
Yeah, I kind of have some background, but if you want to ask a general question, you know, let's try to, you know, keep specifics out of it just because of the purpose of there's no confidentiality here. We are streaming and it's just meant for some general legal information to assist you.
Okay, good. Yeah, I do have a good general question here, I guess, in terms of jurisdiction and filing a civil lawsuit that's on somebody that's outside of the state where I live at. So yeah, just if between federal or a local court, if there's a person that has made communications out of his own state that about my character or associating my reputation and sent communications to people from into another state or at like that, would that be a federal jurisdiction?
Mm-hmm.
If he's using electronic communication?
Yes.
That kind of thing.
All right. Well, let's talk about jurisdiction. There is state jurisdiction and federal jurisdiction. To have federal jurisdiction, you need diversity of citizenship plus an amount in controversy over, I believe, 75,000. I could be wrong about the amount. It might be 50,000. It's all by United States code, but you need diversity of citizenship plus the sufficient amount in controversy to get into federal court. All right. But state courts are matters of general jurisdiction. And in order for you to have contacts with that state, for that state court to have authority, jurisdiction over the individual, it's based on, I believe the case is international shoe. You want to look up the international shoe doctrine about minimal contacts with that state in order for the state to have jurisdiction. Now, you said it was an out-of-state defendant who's making communications. I don't know what type of communications or how, or if they're sufficiently touching. It's about touches to the jurisdictional state for that state to have jurisdiction, authority, power to make a decision over this individual. Okay. So it's all about minimal contacts, and you can argue it. Yeah. Maybe they're sending a text message to you from out of state, but they knowingly know that you are located in state. That's a touch. That's arguably a touch. They have availed themselves. The principle is, have they availed themselves to the benefit of the state's laws in order for the state to have jurisdiction over them? It happens all the time, these type of questions. A lot of times with companies that are registered in another state but advertising in a different state. Because of their efforts targeting that state, they have availed themselves open to the benefits of that state's laws, and therefore the state has jurisdiction over them to make a decision in any dispute. Okay. So you want to look up the international shoe standard for minimal contacts.
Okay. Are you saying international? How do you spell the last word? Shoe?
Shoe, just like the shoe you put on your foot.
Okay.
Yeah. It's an old case, but a goodie. It's been around for it's been around for a while.
Okay. That's and just the only other concern I have is a general question too, is just if he finds out that I'm on to him, I don't want him to have the chance to delete this information? I mean, it would, I don't know how to get them to preserve the evidence.
Preserving evidence.
Yes. Make him preserve the evidence that he's been, on his, on this app and his emails, basically. So,
Okay. Well, first things first is you can't control what someone else does. It's impossible. All right. But what we can do is assert your rights and place upon them legal duties to preserve evidence. And we do that with what we call a spoliation notice. Whenever there is a anticipation of a pending litigation and you send a notice to preserve evidence, that is what we call a spoliation notice. And if you can prove evidence was destroyed after receiving notice, then you can have certain presumptions in your favor at the time of trial. So it's important to send a spoliation notice, but it has to also be done by a way in which you can verify that it was sent and received. So either by certified mail with tracking or by a registered process server is the best way to serve a spoliation notice. Yeah. In these situations, look, the legal system is totally open for everyone. That's what it's there for. The court is where we resolve our disputes in society. However, when you go forward with doing these certain legal suggestions to preserve your rights, it's a thin line. You have to be very careful on the way things are drafted and communicated, because as a private individual, you run the risk of also incurring liability for extortion in certain situations. You have to be very careful about how you phrase things and the way you make any type of demands, because it could be considered extortion. All right. Extortion or defamation or interfering with people's business advantages, business interests. So you have to be mindful. As an attorney, when we submit these type of requests and notices under attorney letterhead, we have somewhat of a protection in the form of the litigation privilege. We're allowed to assert certain things within reason and within the law, but we're allowed to assert certain things under the guise that it's in furtherance of litigation. So we have somewhat of a protection, and it protects the client so that they do not incur liability for potential extortion or interference type claims. So you have to be, all I'm saying is you have to be very careful. It's better if you do proceed under the guidance of an attorney with representation, not just, consultation of an attorney, but representation. Have an attorney stand in for you and make these demands and requests so that you are protected and shielded from any type of counterclaims. No, he's just coming after me, trying to extort me, trying to defame me. You need to go under the umbrella of an attorney privilege communication. Okay. But
I appreciate that advice.
That's also not suggesting that you can't do it. All I'm saying is I'm forewarning you, because there are risk and liability that you too also must consider.
Okay. Good advice, man. I appreciate it.
Yes. And if anyone wants to speak more about specifics, feel free to reach out and we can book a confidential consultation. We are here every Monday. You can consider this a place to tap in and just stay up to date on your legal issues. Okay. If anyone online, I see that we have Tim messaging in the chat. If you have any questions, we do read the chat. And if you want to chime in, I'd be happy to address it. We could probably stay on for another minute or two. I do like to keep these meetings to about 20 minutes or so, just so we can all get the week started. Let me just check on the chat. If not, we can adjourn, and feel free to log back on next week. Log back in with the same issues. We can just give an accountability update check. No problem. We do stream. We're streaming on Facebook, LinkedIn, YouTube, and Twitter. So with that, I just want to say thank you. Thank you, Anthony. Thank you, Juan. Thank you, Jonathan. Thank you, Chelsea. And take care and take action. We'll see you next week. Bye-bye.